Before we begin, a quick and important disclaimer. The information provided in this video is for educational and informational purposes only. It is not intended to be, and should not be taken as legal or financial advice. We are not lawyers or financial advisors. You should consult with a qualified professional for advice tailored to your individual situation. Imagine a surgeon, a top-of-their-class steady-handed genius who has successfully performed thousands of complex operations. Then one day on a routine procedure their hand slips. Just a millimeter. But that 1 millimeter changes a life forever. Now imagine a lawyer. Let's call him David. David is a partner at a prestigious firm in downtown Chicago. He's a killer in the courtroom, known for his meticulous preparation and closing arguments that are the stuff of legend. He handles multi-million-dollar corporate mergers. For 20 years, his record has been flawless. Then, on a Tuesday afternoon while juggling 3 massive cases, his paralegal misfiles a single document. A deadline for an appeal is missed. Not by a week, not by a day, but by 1 hour. And just like that, his client's $100 million case evaporates. It's gone. Not because they were wrong, not because they didn't have a case, but because of a clerical error. A human error. For David, that single mistake is the financial equivalent of a nuclear bomb detonating in the center of his career. What happens next is something the legal profession almost never talks about in public. It's the skeleton in the closet of every single law firm in the United States, from the solo practitioner in a small town to the 1,000-lawyer behemoths on Wall Street. It's a multi-billion-dollar industry built on a single terrifying premise: that the person you trust with your money, your freedom, and your future is going to make a mistake. A big one. This is the world of legal malpractice insurance, or as it's known in the industry, errors and omissions coverage. And it is the source of a deep secret anxiety for nearly every practicing attorney in America. You might be thinking, okay, insurance for mistakes, so what? Doctors have it, accountants have it. But you have to understand the psychology is completely different. We hire lawyers to be paragons of perfection. We pay them enormous sums of money to navigate a system of impenetrable complexity, to be our champion, to catch the details no one else sees. Their entire professional identity is built on being the one person in the room who does not and cannot mess up. Yet, an entire industry exists solely because they do. It's the ultimate paradox. The people we pay to be infallible are protected by a system that assumes their failure is not just possible, but probable. In this video, we are pulling back the velvet curtain. We're going deep inside the one topic that makes lawyers visibly uncomfortable. We're going to expose why this insurance isn't just a simple safety net. It's a golden cage. You're going to learn what it is, how it secretly shapes the legal advice you receive, and why the cost of it is skyrocketing, creating a crisis that's threatening the very structure of law firms across the country. And most importantly, by the end of this, you'll understand the one critical question you need to ask any attorney before you ever sign a retainer. A question that can reveal more about their practice than any online review ever could. This isn't just for people who need a lawyer. This is for anyone who wants to understand the hidden mechanics of power and risk in the American justice system. So, what exactly is this insurance? On the surface, it's simple. If a lawyer commits an act of negligence, a missed deadline, bad advice, a conflict of interest that harms a client financially, the insurance policy pays for the lawyer's legal defense, and if necessary, the settlement or judgment. But that's where the simplicity ends. Because a malpractice claim is not just a financial problem for a lawyer. It is an existential threat. It's a direct assault on their professional competence, their reputation, and their integrity. Think about it. A doctor can argue that biology is unpredictable. An architect can blame a subcontractor. But when a lawyer makes a mistake, the fault is almost always squarely on them or their firm. It was their job to know the law, to meet the deadline, to file the paperwork correctly. This is why the fear runs so deep. A 2021 study by the American Bar Association found that a staggering 80% of lawyers will face the threat of a malpractice suit at some point in their careers. Let me repeat that, for out of every 5 attorneys, this isn't a remote possibility, it's a statistical near certainty. The claims aren't just coming from disgruntled clients who lost a case they should have lost. They come from everywhere. They come from complex real estate deals where a zoning ordinance was misinterpreted. They come from estate planning where a beneficiary was accidentally left out of a trust. They even come from clients who won their case, but believe they should have one more. The pressure this creates is immense. Every email a lawyer sends, every piece of advice they give over the phone, every document they draft, carries with it the potential for a career-ending mistake. It's a constant, low-grade hum of anxiety in the back of their minds. And this anxiety has a profound, often invisible, effect on how they practice law and, by extension, on the clients they serve. For example, has a lawyer ever seemed overly cautious, recommending a settlement in a case you felt was a slam dunk? It might not be because your case is weak. It might be because they are engaging in what's known as defensive lawyering. They're subconsciously steering you toward the path of least resistance, the path with the lowest possible risk of a claim being filed against them, even if a riskier path might have led to a bigger payout for you. The insurance companies know this. They aren't just passive observers. They are active participants in shaping legal practice. They conduct rigorous audits of law firms. They scrutinize their docketing systems, the calendars they use to track court dates and deadlines. A single missed deadline is the #1 cause of malpractice claims, so insurers are obsessed with it. They dictate the kinds of cases a firm can take on. If a firm has a history of claims in, say, intellectual property law, their insurer might demand they stop practicing in that area altogether or face a premium increase so massive it would put them out of business. They are the unseen puppet masters, pulling strings of risk and capital that force law firms to be more conservative, more standardized, and in some cases, less willing to take on the novel or difficult cases that push the boundaries of the law. And the cost is simply staggering. For a small firm, a basic policy might start at $5,000 or $10,000 a year. But for a larger firm involved in high-stakes litigation like securities or mergers and acquisitions, the premiums can easily run into the millions of dollars annually. That cost, of course, doesn't just disappear. It gets baked directly into the lawyer's hourly rate. It becomes part of the overhead that you, the client, are paying for every time you pick up the phone. You're not just paying for their expertise. You're paying for the ever-present fear that their expertise might fail them. You are subsidizing their safety net. But what happens when that safety net breaks? What happens when a claim is so large, so catastrophic, that it exceeds the limits of their insurance policy? This is the nuclear verdict scenario that keeps managing partners awake at night. And it's happening more and more. We're going to dive into those cases. We'll look at the story of a law firm that was forced to declare bankruptcy after a single error in a patent case. We'll explore the most dangerous areas of law to practice. And the answer will absolutely surprise you. It's not criminal defense or personal injury. We'll also break down the anatomy of a malpractice lawsuit. From the initial client complaint to the brutal discovery process where every email and memo from the lawyer is put under a microscope. And we'll reveal why, in a shocking twist, Oregon is the only state in the entire country that requires its lawyers to carry this insurance, leaving clients in the other 49 states in a precarious position they may not even be aware of. The system is far more fragile than you think, and understanding its weaknesses is the first step to protecting yourself. So, why is this the reality? Why would a profession built on rules, regulations, and protecting others leave such a massive, gaping hole in its own safety net? The answer, like most things in law and politics, comes down to a powerful combination of money, influence, and a carefully crafted narrative. The official line from many state bar associations, the very organizations that regulate lawyers, is that mandating malpractice insurance would be bad for you, the client. The argument goes like this: forcing every lawyer to buy insurance would dramatically increase their overhead. This is especially true for solo practitioners or those in small towns who serve lower-income communities. To cover these new mandatory costs, they'd have to raise their hourly rates. Suddenly, legal help that was barely affordable becomes completely out of reach for the people who need it most. The result, they claim, would be a crisis of access to justice. Small firms would go out of business, lawyers would flee rural areas, and the only ones left standing would be massive corporate firms charging $500 an hour or more. It sounds noble, doesn't it? Sounds like they're protecting the little guy. But let's peel back that onion for a second. Let's really examine what that argument implies. It suggests that in order to keep legal services cheap, we must accept that some of those services will be, well, uninsured. It creates a tiered system of justice right from the start. If you can afford a lawyer from a big, prestigious firm, you can rest assured they are insured to the hilt. Their clients, their reputation, and their partners demand it. But if you're the person using that solo practitioner in a small town, you are being asked to silently accept the risk of your lawyer's potential negligence. You are the one bearing the financial risk if they make a catastrophic mistake. The system is essentially telling you, we'll give you access to a lawyer, but we offer no guarantee of a remedy if that lawyer ruins your life. It's like a hospital saying, our surgeons are cheaper because we don't require them to have malpractice insurance. Good luck. You would never accept that. So why do we accept it from the legal profession? This is where the story of a man we'll call David comes in. David was a welder, a skilled craftsman who ran his own small fabrication shop. After years of hard work, he landed the biggest contract of his life, a multi-year deal to provide custom metalwork for a new commercial development. It was his ticket to financial security, a chance to hire more people from his community, and build a legacy for his kids. But the contract was complex. He knew he needed a lawyer to look it over. He found a local attorney, a man with a good reputation who'd been practicing for 30 years. His office was modest, his prices were reasonable, and he seemed trustworthy. David paid him a retainer and handed over the contract. Weeks turned into months. The lawyer kept giving excuses. "I'm waiting to hear back from their counsel. We're just hammering out a few minor details." David, trusting the professional, didn't push too hard. Then one day, the developer called him directly. "David," the man said, "we haven't heard from your lawyer in 3 months. The deadline to sign passed 2 weeks ago. We've had to move on and award the contract to another company." David's world imploded. He confronted his lawyer, who finally admitted the truth. He had been overwhelmed with other cases, had suffered some personal problems, and had simply dropped the ball. He had never even responded to the developer's final offer. He just forgot. The contract and David's future with it had vanished into thin air because of a missed deadline. This wasn't a complex legal misinterpretation. It was a basic, fatal error. It was malpractice, clear as day. Devastated but determined to seek justice, David hired a second lawyer to sue the first one for his negligence. And that's when the second hammer fell. The first lawyer, the one who had practiced for 30 years, had no malpractice insurance. He never had. His modest office, his old car, that was it. He had no significant assets to his name. He was, in legal terms, judgment-proof. You can sue him and win $1 million judgment from a jury, but that piece of paper is worthless if the person you're suing has no money and no insurance company to back them up. You can't get blood from a stone. David lost his business, his savings, and was forced into bankruptcy. The system that was supposed to protect his rights had provided him with an attorney who, through a simple act of negligence, destroyed his life, and the system offered absolutely no recourse. He had paid for a safety net and discovered it was just a drawing of a net on the floor. David's story isn't a 1 in a million freak accident. It's the predictable outcome of a system that prioritizes the comfort of its members over the protection of the public. Now you might be thinking, surely there's some rule? Don't they have to at least tell you they're uninsured? And in many states you'd be right. As the push for mandatory insurance failed again and again against the lobbying of powerful bar associations, a weak compromise emerged: disclosure. The rule in many jurisdictions is that if a lawyer doesn't carry malpractice insurance, they must disclose that fact to their client in writing. It sounds like a reasonable solution, right? Forewarned is forearmed. But in practice, it's a fig leaf. This disclosure is often buried deep within a multi-page engagement letter or fee agreement, filled with dense legalese that most clients sign without reading closely. It might be a single sentence on page 7, right between a clause about billing increments and another about document retention policies. The client, who is often in a state of crisis, facing a lawsuit, a divorce, a criminal charge, is focused on their problem, not on the fine print of their lawyer's administrative paperwork. They trust the lawyer. They assume the system has protections built in. This disclosure rule is a classic example of shifting the burden. It takes the responsibility off the professional and places it squarely on the shoulders of the vulnerable and often legally unsophisticated client. It allows the Bar Association to say, "We solved the problem," while knowing full well that the solution is functionally useless for the vast majority of people. It preys on a fundamental psychological bias. We are conditioned to believe that licensed professionals, doctors, accountants, lawyers, are part of a system that holds them accountable. We see the university degree on the wall, the state bar certificate, the shelves of thick, important-looking books, and we assume that a robust regulatory structure is standing behind them. This assumption of safety is the very thing that makes the lack of a real safety net so dangerous. The entire legal profession is cloaked in an aura of security and dependability. Yet, in 49 out of 50 states, that cloak can be ripped away to reveal that if your lawyer makes a mistake, you might be completely and utterly on your own. The secret worry for every lawyer isn't just that they'll make a mistake. It's that they know how easily their colleagues can make one. And they know that in many cases, there is absolutely nothing to catch the client who falls. The question then becomes, what kind of mistakes are we talking about? Is it just missed deadlines like in David's case? Or is it something far more common and far more insidious? The most frequent malpractice claims aren't born from elaborate courtroom blunders, but from simple everyday tasks that lawyers perform thousands of times. And the number one cause of malpractice is something you'd never ever expect. It's a missed deadline, a simple catastrophic calendaring error. It sounds almost laughably mundane, doesn't it? In a profession built on high-stakes drama, intellectual combat, and eloquent arguments, the single greatest threat to a lawyer's career isn't a brilliant opposing counsel or a hostile judge. It's a typo, a single misplaced digit in a calendar entry that can detonate a career with the force of a bomb. To understand the sheer terror this concept holds for attorneys, let me tell you about a lawyer we'll call Michael. Michael wasn't a superstar, but he was a damn good lawyer. He ran a small personal injury firm in a mid-sized city. Just him, 2 paralegals, and a receptionist. He was the kind of lawyer you'd want if you were in trouble. Diligent, empathetic, and a bulldog when he needed to be. He'd built his practice from the ground up, and he was proud of it. He was handling about 40 active cases, which for a small firm is a constant high-wire juggling act. One of his cases involved a woman named Elena. She was a schoolteacher in her late 40s, and her life had been turned upside down. She was stopped at a red light when a commercial truck, whose driver later admitted to texting, plowed into the back of her sedan at 50 miles per hour. The accident was brutal. Elena suffered 2 herniated discs in her neck and a traumatic brain injury that left her with chronic migraines and memory problems. She couldn't teach anymore. Her medical bills were already in the 6 figures and climbing. For Michael, this was what lawyers call a slam dunk on liability. The trucking company was clearly at fault. The only question was damages. How much was Elena's shattered life worth? The company's insurance carrier was playing hardball, offering a lowball settlement that wouldn't even cover her existing medical debt. Michael assured Elena, "Don't worry, they're just trying to scare you. We have the law, we have the facts. We'll file a lawsuit and make them pay what's fair." Elena trusted him completely. He was her champion, her only hope. In every personal injury case, there is a fuse burning. It's called the statute of limitations, the absolute deadline by which a lawsuit must be filed. In Michael's state, for this type of case, it was 2 years from the date of the accident. 2 years. 730 days. Miss it by 1 day, 1 hour, 1 minute, and your client's right to sue is extinguished. Forever. The accident happened on March 15, 2021. The deadline to file the lawsuit was March 15, 2023. Michael knew this. His whole team knew this. When the case came in, his lead paralegal, a seasoned professional named Karen, opened the file and entered the critical date into their case management software. But on that particular afternoon, Karen was being pulled in a dozen different directions. The phone was ringing off the hook, another client was in the lobby, and Michael had just asked her to urgently find a document for a different case. In that flurry of activity, her fingers flew across the keyboard. She typed in the deadline, March 15, 2024. A single keystroke error. A 4 instead of a 3. The digital time bomb was set. And for the next year it ticked away silently, hidden in plain sight. Michael and his team worked Elena's case diligently. They hired experts, took depositions, and compiled a mountain of evidence documenting the severity of her injuries and the negligence of the trucking company. They engaged in protracted negotiations with the insurance adjuster. Michael was confident. He had the company dead to rights. He kept telling Elena to be patient, that their position was strong, and that they had plenty of time. They had until March of next year, after all. In February of 2024, a full 11 months after the real deadline had passed, the insurance company gave their final offer. It was still insultingly low. Michael, righteous and indignant on Elena's behalf, slammed down the phone. "That's it," he said to Karen. "They want to play chicken? Fine. Prepare the complaint. We're filing." They spent the next week polishing the lawsuit, making it perfect. They filed it with the court on February 28, 2024. Michael called Elena. "It's done," he said. "We're officially taking them to court. Now the real fight begins." Elena was relieved, grateful. About 10 days later, a thick envelope arrived from the trucking company's defense firm. Michael assumed it was their formal answer to the lawsuit. He opened it casually, sipping his morning coffee. It wasn't an answer. It was a motion to dismiss. He scanned the first page, his eyes gliding over the legal boilerplate until they landed on a single sentence. Plaintiff's claim is barred by the 2-year statute of limitations, which expired on March 15, 2023. The coffee cup stopped halfway to his mouth. The world seemed to slow down. Felt like a typo. A joke. He thought, these guys are idiots. They can't even get the year right. He walked over to the file cabinet, his heart starting to beat a little faster. He pulled Elena's thick folder, his hands feeling strangely clumsy. He flipped to the front to the initial client intake form. He looked at the police report. Date of accident, March 15, 2021. A wave of nausea washed over him. A cold metallic taste filled his mouth. He stumbled back to his computer, his hands shaking as he clicked open the case management software. He navigated to Elena's file, to the calendar page. And there it was. The deadline. Staring at him from the screen in cold, digital certainty. March 15, 2024. The typo. The single fatal for instead of a 3. In that moment, Michael's world collapsed. Elena's case was gone. Her only chance at getting the money she desperately needed for her future. For her medical care, for her life, it had vanished. Not because of a brilliant legal argument, not because a jury didn't believe her, but because of a typo made by an overworked paralegal almost 2 years earlier. The case was over before it ever began. The court granted the motion to dismiss. It was a legal certainty. Now came the worst part. Michael had to pick up the phone and call Elena. He had to explain to this woman who trusted him, who saw him as her savior, that he had failed her in the most fundamental way imaginable. He had to tell her that her case was worth 0, and it was 100% his fault. And that's when the nightmare truly begins. Because Elena, justifiably heartbroken and furious, is now going to sue Michael. And this is where the specter of lawyer insurance becomes an all-consuming terror. The malpractice claim against Michael won't be for the fees he charged. It will be for the value of the case he lost. The trucking company's defense attorneys, in a cruel twist of irony, will now become Elena's greatest allies. They will hire experts to argue that Elena's original case was worth millions. 5 million, maybe 10 million. Every piece of evidence Michael so carefully gathered to prove the value of Elena's suffering will now be used as a weapon against him. His slam-dunk case for his client has become a slam-dunk malpractice case against himself. His insurance policy, which once felt like an abstract, annoying business expense, is now the only thing standing between him and total financial ruin. His firm, his house, his kids' college funds, all of it is on the line, held hostage by a single keystroke. This is the tyranny of the calendar. It's the number one fear because it has nothing to do with being a brilliant lawyer and everything to do with being a fallible human being running a complex operation. It's the secret knowledge that one tiny administrative slip-up by anyone on your team at any time can end everything you've ever worked for. But what if the mistake isn't a date on a calendar? What if the mistake is in who you choose to represent in the first place? The second biggest driver of malpractice claims is a trap that even the most careful lawyers fall into, and it has nothing to do with legal strategy and everything to do with human psychology. It's called client selection, and getting it wrong can be even more devastating than missing a deadline. Think of a law practice not as a hospital, but as a hospital's emergency room admissions desk. The lawyer isn't just the surgeon, they're the triage nurse. And their most critical decision, the one that can save the practice or burn it to the ground, is deciding which patients to admit. Because some clients aren't just sick, they're contagious. They carry the virus of a future malpractice claim, and they're looking for a host. This is the dark art of client selection. It's where a lawyer's gut instinct is often more valuable than their law degree. Let's start with the most deceptively dangerous client, the expert. This isn't an expert in their own field. They're an expert in yours. They arrive for the initial consultation with a stack of printouts from quasi-legal websites and a speech prepared. They've already diagnosed their own legal problem, prescribed the exact legal motion that needs to be filed, and calculated their damages down to the penny. They aren't hiring a lawyer. They're hiring a stenographer with a bar license to execute their flawed vision. Imagine a small business owner, let's call him Frank, who is being sued by a former partner. Frank marches into a lawyer's office, drops a box of documents on the desk and says, "It's an open and shut case of fraud. I read online that we need to file a motion for summary judgment immediately and countersue for punitive damages. Don't let them bog you down in discovery." The young lawyer, eager for a paying client, is hesitant. She knows that filing for summary judgment this early is pure fantasy. You need evidence, you need depositions, you need a case. But Frank is insistent, and more importantly, he's writing the check. So the lawyer tries to manage him. She files other, more appropriate motions. She tries to explain the strategy. But every email from Frank is a new article he found, a new theory he has. He second-guesses every decision. The lawyer spends more time managing Frank than managing the case. In the end, she secures a decent settlement for Frank, saving him from a potentially catastrophic loss at trial. But in Frank's mind, it's a failure. He's convinced that if she had just listened to him, if she had filed his motion, he would have won millions and crushed his enemy. A month later, the lawyer is served with a malpractice lawsuit. The claim? Failure to follow the client's instructions and negligently settling the case for too little. She did everything right by the book, but she made her fatal error the moment she shook Frank's hand. She admitted a patient who refused to believe he was sick. Then you have the opposite but equally toxic archetype, the desperate. This client is often the most sympathetic. They've been wronged, their story is heartbreaking, and they've been turned down by every other lawyer in town. They have no money to pay up front, but they're sitting on a guaranteed multi-million-dollar winner of a case. This is a siren song for lawyers with a savior complex, or for those who are just starting out and hungry for a big score. Picture a lawyer taking on a slip-and-fall case. The client, a woman named Maria, claims she slipped on a wet floor in a grocery store with no wet floor sign. It sounds straightforward, but as the lawyer digs in, the story starts to fray. The incident report says Maria was wearing stilettos in a rainstorm. The store has video footage showing a sign was present, just a few feet away. Maria's own deposition is full of inconsistencies. The case is a dog. Any experienced attorney would see the writing on the wall and cut their losses. But our lawyer has already invested months and thousands of dollars of his own money. More than that, he's invested his ego. He believes Maria. He feels for her. He takes the case to trial and gets wiped out. The jury is out for 20 minutes. Now Maria, who had nothing, is not just disappointed, she's furious. Her desperation curdles into blame. She had convinced herself this lawsuit was her lottery ticket, her one way out of a tough life. And the lawyer, her supposed savior, failed her. She has nothing to lose, so she files a malpractice claim. The grounds? The lawyer should have known the case was a loser and never taken it. Or he should have settled it. Or he should have found a different expert witness. It doesn't matter what the reason is. The claim isn't about legal merit. It's an act of pure, desperate retribution. The lawyer took on a client who was drowning, and in the end she just pulled him under with her. Next is the ghost. The client who is all in at the beginning then vanishes. They are enthusiastic, they sign the retainer agreement, they pay the initial fee, and then, radio silence. Emails go unread. Voicemails are not returned. Certified letters come back unclaimed. This is a special kind of hell for a lawyer because the case is still active. The court's deadlines don't stop just because your client is incommunicado. The opposing counsel is still filing motions that require a response. The lawyer is ethically handcuffed. They can't make major decisions without the client's consent, but they can't get that consent. Think about a contentious divorce case. The lawyer represents the husband. They need financial documents from him to respond to a discovery request from the wife's attorney. The deadline is Friday. The lawyer has been calling, emailing, texting for 2 weeks. Nothing. The deadline passes. The wife's attorney files a motion to compel and asks the judge for sanctions, for the husband to pay their legal fees for having to file the motion. The judge grants it. The lawyer is now in a position where their client has been penalized by the court, and it's arguably because the lawyer failed to get a response. Suddenly, a month later, the client reappears. He was on a spiritual retreat with no cell service. He's outraged that the judge sanctioned him and that his case is in trouble. Who does he blame? Not himself for disappearing. He blames his lawyer. Why didn't you do something? You're my attorney. You let them walk all over me. That anger festers. When the final divorce decree isn't to his liking, he sues the lawyer, claiming his poor outcome was a direct result of those missed deadlines early on. The lawyer was captaining a ship, but the client intentionally threw the rudder overboard and then sued him for crashing. Finally, there's the most common and insidious problem client of all, the lottery ticket holder. This client has been conditioned by television and sensational news headlines to believe that the legal system is a slot machine. They see a minor fender bender and envision a 7-figure payout. They view any settlement offer that doesn't include a mansion and a lifetime supply of everything as a personal insult. The lawyer's most important job in these cases is to brutally, relentlessly, and repeatedly manage expectations. But in the heat of signing a new case, it's easy to be optimistic. The lawyer might say, "This is a very strong case, and we're confident we can get you a fair result." The client, however, hears, "This is a winning lottery ticket, and you're about to be rich." The lawyer presents a settlement offer from the insurance company for $50,000. A fantastic result based on the actual medical bills and facts of the case. The client is appalled. They saw a commercial where someone got $2 million for a similar accident. They accuse the lawyer of being lazy, of being in cahoots with the insurance company, of selling them out for a quick payday. They refuse the settlement and demand a trial. At trial, the jury awards them $20,000, less than half of what they were offered. Now the client is incandescent with rage. The lawyer didn't just lose, they were incompetent. They gave bad advice. They should have forced the $50,000 settlement. The malpractice suit practically writes itself. These four archetypes, the expert, the desperate, the ghost, and the lottery ticket holder, are the four horsemen of the legal malpractice apocalypse. And insurance carriers know them by name. When a lawyer applies for malpractice insurance, the application is an interrogation. They ask about your intake procedures. What percentage of your cases are contingency? How do you screen clients? Do you have a history of suing clients for unpaid fees? A massive red flag that you're picking the wrong people to begin with. Because the insurance company knows a fundamental truth. A lawyer can be a brilliant legal mind, a master strategist, a silver-tongued orator in the courtroom, but if their judgment fails them before the client even signs the retainer agreement, none of that matters. They're ensuring the lawyer's most important and least taught skill, the ability to say no. But even if a lawyer successfully navigates this psychological minefield and chooses the perfect client with the perfect case, they are not safe. Because the greatest threat isn't always the person sitting across the desk. Sometimes the threat is buried in their own office, a ticking time bomb made of paper, calendars, and keystrokes. It's the silent, unassuming force that has destroyed more legal careers than any difficult client ever could. We call it the administrative abyss. It's not an enemy you can cross-examine or a legal precedent you can argue against. It's the relentless, grinding machinery of a modern law practice itself. It's the mountain of paperwork, the endless stream of emails, the critical deadlines that fly by like telephone poles on a highway. And the single most common cause of a career-ending malpractice claim isn't a brilliant courtroom maneuver by an opponent. It's a missed deadline. A simple, stupid, catastrophic clerical error. Let me tell you about a lawyer we'll call David Chun. David wasn't some fly-by-night ambulance chaser. He was the real deal. Top of his class, 15 years of experience, and a reputation for being surgically precise. His small firm in Austin, Texas, specialized in complex personal injury cases, the ones other lawyers turned down. David was known as the guy who found the details everyone else missed. His office wasn't flashy, but it was a well-oiled machine. Or so he thought. A few years ago, a man named Mark walked into his office. Mark was a scaffolder, a guy who spent his days walking on steel beams 100 feet in the air. One afternoon, a faulty harness, supplied by a third-party contractor, gave way. Mark didn't fall to his death, but he might as well have. He fell 20 feet onto a concrete slab, shattering his pelvis and fracturing 3 vertebrae. His career was over. His life of constant, grinding pain was just beginning. The case was, in legal terms, a slam dunk. The evidence against the harness manufacturer was overwhelming. They had cut corners, used substandard materials, and there was a clear paper trail to prove it. David and his team estimated the potential damages, medical bills, lost future earnings, pain and suffering, in the neighborhood of $8 million. For Mark, this money wasn't a lottery ticket. It was the only thing that stood between him and a lifetime of poverty and dependence. It was the money that would pay for the surgeries he would need for the rest of his life, the modifications to his home, the care he could no longer provide for himself. David took the case and his team got to work. They filed the initial notices, they gathered depositions, they hired experts. For 2 years, the case moved along like countless others. It was a marathon, not a sprint, and David's firm was built for endurance. The single most important date in the entire case was the statute of limitations. In Texas, for a case like this, you have 2 years from the date of the injury to formally file a lawsuit in court. If you miss that date by 1 minute, the case is gone. It ceases to exist. It becomes legal dust. That date was logged in their system. It was on David's calendar, his paralegal's calendar, and the firm's master calendar. It was backed up on a cloud server. They had redundancies for their redundancies. The date was circled in red, October 14th. In early September, about 6 weeks before the deadline, David's longtime paralegal, a woman who was the organizational bedrock of the firm, had to take an emergency leave of absence to care for her ailing mother. A temp was brought in capable but new to the firm's specific systems. Around the same time, the firm was migrating to a new, state-of-the-art case management software. The transition was supposed to be seamless. The tech company promised all existing data, all critical dates, would be perfectly imported. The perfect storm was brewing, and no one even saw the clouds. The new software had a glitch, a tiny imperceptible bug in the code. When it imported the calendar data, a handful of dates, randomly it seemed, were shifted forward by 1 month. The statute of limitations for Mark's case, October 14th, was now displayed in the new system as November 14th. The old system had been decommissioned. The physical wall calendar was taken down during a minor office renovation. The human backup, the paralegal who knew these dates like the back of her hand, was hundreds of miles away. Every single safety net had been removed by a series of completely unrelated, innocent events. On the morning of October 15th, David Chun walked into his office with a coffee in his hand, feeling good. They were in the home stretch on Mark's case. He sat down at his desk, opened the file to review his notes for the lawsuit he planned to file in the coming weeks, and he saw the date of the accident. And then he froze. A cold, metallic dread washed over him, the kind of dread that starts in your stomach and shoots up into your throat. He looked at the calendar on his computer screen. October 15th. He frantically pulled up the new case management software. It said the deadline was November 14th. But his gut, the instinct of a 15-year veteran, was screaming at him. He scrambled to find the original client intake form, a physical piece of paper in a file buried deep in a cabinet. He found it. Date of incident, October 14th, 2 years ago. The deadline wasn't a month away. It was yesterday. For 10 minutes, David just sat there in his expensive chair, in his successful office, and felt his entire world collapse into a black hole. He had built his entire career, his entire identity, on being the man who never missed a detail. And he had just missed the only detail that mattered. A multi-million-dollar, life-changing case for a man who had trusted him completely had just vanished into thin air, because of a software glitch and a perfect storm of bad luck. But the law doesn't care about bad luck. The law doesn't care about software glitches or personal emergencies. The law cares about the date. And the date was yesterday. He had to make the call. It's a call that every lawyer has nightmares about. He picked up the phone and dialed Mark's number. He had to explain that the $8 million was gone. He had to explain that the company that had crippled him would never pay a dime. He had to explain that it was his fault, his firm's fault. He had to listen to the silence on the other end of the line, a silence that quickly turned into confusion, then disbelief, then the raw, agonizing sound of a broken man's hope finally being extinguished. When David hung up the phone, he was no longer Mark's advocate. He was now his adversary, because Mark's only remaining path to justice, his only way to recover the money he so desperately needed, was to file a new lawsuit. A legal malpractice lawsuit against David Chun. The hunter had become the prey. The protector had become the target. David's meticulous, celebrated career was now hanging by a single thread, and that thread led directly to his professional liability insurance policy. He had spent his life fighting for others, but now he was facing a fight for his own survival. And that's when he had to make a second, even more terrifying call. The call to his insurance carrier. A call that would begin a new kind of war. One fought not in a courtroom with rules of evidence and a jury of his peers, but in a labyrinth of policy exclusions, reservation of rights letters, and impenetrable fine print. That call is one of the loneliest moments in a lawyer's life. On one end of the line is you, a professional trained in the art of advocacy, persuasion, and control. On the other end is a claims adjuster, a person whose entire professional existence is dedicated to a single cold calculus. Risk mitigation and cost containment for the insurance company. They might sound friendly, empathetic even. They'll use phrases like, "We're here to help," and "Let's get this sorted out." But every lawyer knows, deep in their gut, that this is not a conversation between allies. It's the opening move in a chess match where your opponent not only knows all your moves in advance, They designed the board and wrote the rules. The lawyer in our story hangs up the phone, but the expected wave of relief never comes. In its place, a cold dread begins to seep in. He's done the right thing, he's reported the claim. But in doing so, he has voluntarily handed the keys to his kingdom, his files, his reputation, his future, over to a multi-billion-dollar corporation whose primary fiduciary duty is to its shareholders, not to him. A few days later, a thick envelope arrives by certified mail. It's from the insurance carrier. This isn't a welcome packet. This is the official declaration of the new war. Inside is a document that is, for many attorneys, the single most terrifying piece of correspondence they will ever receive. It's called a reservation of rights letter. To a non-lawyer, the name sounds innocuous, almost procedural. But to the lawyer who understands its implications, it's a dagger wrapped in legalese. The letter is a masterpiece of corporate self-preservation. It will typically start by acknowledging the lawsuit and confirming that, yes, they have received the claim. It will then state that the company will appoint and pay for a defense attorney to represent him. This is the spoonful of sugar. Then comes the medicine, a litany of poison pills. The letter will say something to the effect of, while we will provide you with a defense at this time, we are doing so under a full reservation of our rights to later deny coverage, in whole or in part, based on the terms, conditions, and exclusions of your policy. Let me translate that for you. The insurance company is saying, we're going to hire a lawyer to stand next to you in the courtroom for now, but we're also hiring our own team to simultaneously investigate you, your case, and every single thing you've ever done, looking for a loophole. The moment we find one, we will not only stop paying for your defense, but we will also declare that we have no obligation to pay any settlement or judgment against you. You will be on your own, and you will have to pay us back for the defense costs we've already spent. It is the legal equivalent of being thrown a life raft that is actively designed to deflate at the most critical moment. The letter then goes on to list, in painstaking detail, the specific policy exclusions they are already investigating. This is the labyrinth. Every professional liability policy is riddled with them, and they are not vague. They are surgically precise. There's the exclusion for fraudulent or dishonest acts. The problem is, almost every malpractice lawsuit alleges some form of dishonesty, even if it's baseless. The mere allegation is enough for the insurer to hang the reservation of rights on that hook. There's the exclusion for claims arising from business dealings with a client. Did you invest in a client's startup? Did you serve on their board? Coverage denied. There's the exclusion for fee disputes, for claims involving work done for an entity you partially owned, for anything deemed a criminal act. But the most insidious, the most feared of all, is the prior knowledge exclusion. This is the ultimate trapdoor. It states that the policy does not cover any claim if the lawyer knew, or could have reasonably foreseen, that a specific act or error could lead to a claim before the policy period began. Think about that. Client was a little unhappy a year ago. You had a tense phone call but smoothed it over. Now they're suing. The insurance company can now argue that you could have reasonably foreseen that tense phone call would escalate into a claim, and because you foresaw it before you renewed your policy, you're not covered. It turns the lawyer's own professional judgment and experience against them. Every difficult client, every challenging case, every moment of doubt in the past can be retroactively weaponized by the insurer to deny coverage in the present. The lawyer reading this letter feels the walls of his own history closing in on him. And this brings us to the most surreal and terrifying part of the entire ordeal. The insurance company, under this reservation of rights, now hires a defense attorney for our lawyer. This defense attorney is legally and ethically bound to represent our lawyer's best interests. Their duty of loyalty is to him, their client. But who is paying this defense attorney's bills week after week, month after month? The insurance company. This creates what's known as the tripartite relationship, and it is a minefield of conflicting interests. Imagine this. The defense lawyer is interviewing our lawyer to prepare for the case. In the course of that confidential, privileged conversation, our lawyer mentions that tense phone call he had with the client a year ago. He says, after I hung up I had a bad feeling. I thought to myself, this guy might sue me one day. What does the defense lawyer do with that information? That statement is a potential golden ticket for the insurance company. It's a direct admission that could trigger the prior knowledge exclusion, allowing the insurer to deny all coverage and walk away, leaving our lawyer with a massive, uncovered judgment and a bill for all the legal fees to date. Does the defense lawyer, whose primary duty is to our lawyer, keep that information confidential? Or does he have a reporting obligation to the insurance company that hired him and will hire him again for the next 100 cases? The rules say his loyalty is to the insured lawyer. But the reality, the crushing, pragmatic reality of who signs the checks, creates an almost unbearable tension. The lawyer being sued is now in the paranoid position of having to be careful about what he says to his own defense attorney. The one person who is supposed to be his shield and his sword could also be an unwilling informant for the entity that is actively looking for a reason to abandon him. He is now fighting a war on two fronts. In front of him is the former client, armed with a lawsuit. But behind him, where his reinforcements should be, is his own insurance company, holding a knife and studying the weak points in his armor. The safety net has not just disappeared. It has revealed itself to be part of the trap. And the first spring in that trap is a single piece of paper. It often arrives via certified mail, a crisp, formal-looking envelope that feels heavier than it should. It's a letter that, to the untrained eye, looks like good news. It's called a reservation of rights letter. And for any attorney who receives one, it is the sound of the executioner sharpening his axe. The letter begins with a professional, almost soothing tone. It will acknowledge the lawsuit. It will confirm that, yes, the insurance company has received the claim. And then it will say the magic words the terrified lawyer has been waiting to hear. We will provide you with a defense in this matter. For a fleeting moment, the lawyer breathes. The cavalry has arrived. The million-dollar policy is kicking in. The storm will be weathered. But this relief is a carefully crafted illusion, because the very next sentence, or perhaps the paragraph after, is where the poison is injected. It will say something like, however, we will be providing this defense under a full reservation of rights to later deny coverage and withdraw from the defense. Let's translate that from sterile insurance speak into plain English. What the company is actually saying is this: sure, we'll hire a lawyer for you, for now, but we are immediately launching our own separate investigation into you. We are going to use the time we are defending you to actively search for any loophole, any technicality, any fine print exclusion in your 150-page policy that will allow us to abandon you. And the moment we find it, we're gone. You'll be left alone, in the middle of a legal firefight with a mountain of bills. Oh, and one more thing. We also reserve the right to sue you to get back every single penny we spent on your defense up to that point. Good luck. This isn't a safety net. It's a leash. And the person holding it is just waiting for you to stumble. Let's see how this plays out in the real world. Imagine a successful real estate attorney. Let's call him David. David has been practicing for 20 years, has a great reputation, and has dutifully paid his malpractice premiums, quarter after quarter, year after year. Hundreds of thousands of dollars over his career. One day he gets sued. A former client, whose multi-million-dollar commercial development deal fell through, claims David missed a crucial zoning restriction in the contract review. The client is suing for $10 million in lost profits. David is panicked, but he does what he's supposed to do. He immediately notifies his insurance carrier. He forwards the lawsuit. He fills out the paperwork. A week later, he gets the reservation of rights letter. He reads the reassuring part about them providing a defense, and he feels a wave of relief. He schemes past the rest, the dense legalese he assumes is just standard boilerplate. A few days later, he gets a call from a defense attorney, a partner at a big downtown firm, hired by the insurer to represent him. The new attorney sounds sharp, confident. David feels like he's in good hands. But here is what David doesn't see. The insurance company didn't just hire a defense lawyer. They also assigned a senior claims adjuster, a specialist, whose only job is to manage David's file. And that adjuster's primary goal is not David's well-being. It is to minimize the insurance company's financial exposure. The best way to do that? Find a way to deny the claim entirely. So the adjuster goes to work. He pores over David's policy. He's looking for the exclusions. And he finds them. There's usually a whole list. One of the most common and most dangerous is the exclusion for fraudulent or intentionally dishonest acts. Another is for claims arising from acts where the lawyer had prior knowledge of a potential wrongdoing. Now, David didn't commit fraud. He made a mistake. He was overworked, maybe an associate missed the clause, but it was an error, negligence. That's precisely what malpractice insurance is designed to cover. But the insurer doesn't see it that way. They see an opportunity. The claims adjuster sends a memo to the defense lawyer they hired for David. The memo says, as part of your discovery process, please investigate whether Mr. David had any prior knowledge of this zoning issue. Did he know about it and fail to disclose it to his client? Were there any emails, any notes, any indication at all that he was aware of the problem before the deal closed? Suddenly, the defense attorney is in an impossible, deeply conflicted position. His ethical duty is to defend David with everything he's got. But his paying client, the one who will hire him for the next case and the next, is the insurance company. And that company is asking him to dig for dirt on the very man he is supposed to be protecting. Every question the defense lawyer asks David, every document he requests now serves two masters. When he asks David, "Walk me through your review process. Did you have any concerns about this deal at all?" Is he trying to build David's defense? Or is he probing for a hint of prior knowledge that the insurer can use to deny the claim? When he interviews David's former associate, is he looking for facts to show this was an innocent oversight? Or is he hunting for a disgruntled employee who might say, "Oh yeah, we all knew that property was a mess"? This is the secret terror. The lawyer hired to be your shield is also being used as the insurer's sword. He is collecting information that could be used to save you from your former client, but that very same information could be handed over to the insurance company and used to financially ruin you. You are paying for protection from a company that is now paying a lawyer to investigate you under the guise of defending you. And it gets worse. Let's say deep in discovery an old email surfaces. In it, David mentions to a colleague, "This zoning is tricky, we need to be careful." It's not fraud. It's not a smoking gun. It's a diligent lawyer doing his job. But in the hands of a hostile insurance adjuster, it can be twisted. They can now claim this email proves David had prior knowledge of the potential for a problem. Fits the exclusion. The insurance company doesn't wait for the lawsuit to end. They act now. They send David a second letter. This one is not ambiguous. It's a denial of coverage. It states that based on their investigation, they've determined the claim falls under the prior knowledge exclusion. They are withdrawing his defense, effective immediately. The sharp, confident lawyer they hired for him is now gone. So David, in the middle of a $10 million lawsuit, is suddenly alone. He has to find and hire a new lawyer, on his own dime, who has to get up to speed on a complex case that's already been going on for months. But the final insult, the twist of the knife that was promised from the start, is yet to come. A month later, David gets a third piece of mail. It's not a letter. It's a bill. From his former insurance company. It's for $275,000. The cost of the defense lawyer they provided before they abandoned him. The reservation of rights letter stated they could do this. It's called recoupment. They are now suing their own former client to get their money back. David is now facing a three-front war. He is being sued by his former client for $10 million. He is having to pay out of pocket for his own new defense attorney. And he is now being sued by his own insurance company, the people he paid to protect him from this exact nightmare, for over $250,000. The safety net didn't just fail. It has reassembled itself into a cage, and the door just slammed shut. He's trapped. And for thousands of attorneys across the country, this isn't a hypothetical. It is the reality that keeps them awake at night. They aren't just worried about an angry client. They are worried about the supposed ally who is secretly planning to become their executioner. This executioner doesn't arrive with a weapon. It arrives with a letter, a thick cream-colored envelope, sent by certified mail from the insurance company's headquarters. To the attorney, seeing that envelope is a moment of profound relief. Help has arrived. The cavalry is here. Inside, the letter is dense with legalese, but the opening lines are reassuring. "We acknowledge receipt of your claim," it says. "We have retained the prestigious law firm of Smith & Cromwell to defend you in this matter. We will cover the costs of this defense. In accordance with your policy." The attorney breathes a sigh of relief. The weight of the world lifts from their shoulders. But then they keep reading. And they find a single terrifying paragraph buried on page 3. It's a paragraph that changes everything. It's called a reservation of rights. And it is the most elegantly crafted instrument of betrayal in the entire legal industry. In simple terms, the letter says this: "Yes, we will hire and pay for a lawyer to defend you against this lawsuit. We will go through the motions of protecting you, but we reserve the right at any point in the future to decide that your policy doesn't actually cover this claim. And if we make that decision, we will not pay a single penny of any judgment or settlement against you. We'll be gone. You'll be on your own. Imagine your house is on fire. You call 911. The fire department arrives, sirens blaring. They roll out the hoses, connect to the hydrant. The fire chief walks up to you, pats you on the shoulder and says, "Don't worry, we're here to help. We're going to start fighting this fire for you right now." You are flooded with relief. But then he leans in closer and whispers, "Just so you know though, we're going to investigate how this fire started. And if we decide you might have left a candle burning, or used the wrong extension cord, we reserve the right to stop pumping water at any time, pack up our trucks, and leave you to watch your house burn to the ground. But for now, don't worry. We've got your back." That is what a reservation of rights letter feels like. It is the promise of help with the explicit threat of abandonment. The insurance company isn't your ally anymore. They are now an adversary with a front row seat to your downfall. And this creates a horrifying new reality for the attorney: the two-front war. Suddenly, they aren't just fighting the angry ex-client who is suing them. They are now in a second secret war against their own insurance company. A war where every word they say, every document they produce, can be used against them not by the plaintiff, but by the very people paying their legal bills. And who is the general leading the battle in this war? It's the defense lawyer the insurance company hired for them, the so-called prestigious attorney from Smith & Cromwell. This lawyer is now in the most conflicted position imaginable. They have an ethical duty to you, the insured attorney. You are their client. They are supposed to defend you zealously. But who signs their paychecks? Who sends them a steady stream of new lucrative cases year after year? The insurance company. This defense lawyer lives with a fundamental, career-defining conflict. Do they serve the client they're assigned to today? Or do they serve the multi-billion-dollar corporation that will be assigning them clients for the next 20 years? The insurance company knows this. They count on it. They don't have to give explicit instructions. The system is designed to perfection. The defense lawyer knows what the insurance company wants. The insurance company wants to find a way out. They want to find a reason to deny coverage. And so the betrayal begins subtly at first. Let's call our attorney the one being sued. Mark. Mark sits down with his new insurer-appointed lawyer. Let's call him Mr. Davis. Mark expects the conversation to be about a defense strategy, about how to fight the plaintiff's claims. But Davis's questions are strange. He seems less interested in the facts of the case, and more interested in the facts behind the case. He asks things like, "So Mark, when you filled out your insurance application 2 years ago, did you have any inkling this client might become a problem? Or tell me about your firm's internal client intake process. Were there any red flags you might have missed?" Mark, wanting to be helpful, answers honestly. He's an open book. He thinks he's helping his own defense. He has no idea that every answer he gives is being recorded in detailed memos that Mr. Davis is sending back to the insurance company. He doesn't realize that Davis isn't just building a defense against the plaintiff. He's building the insurer's case for denying coverage against Mark. The most diabolical part of this is how the insurance company can use the lawsuit itself to destroy the attorney's coverage. Most malpractice policies have a crucial exclusion for fraudulent or intentionally malicious acts. If an attorney just makes a mistake, a simple act of negligence, they're covered. But if they intentionally deceived a client, that's fraud, and the insurance company owes them nothing. Now, consider the lawsuit against Mark. The plaintiff, to maximize their leverage, has sued Mark for negligence, but they've also included a count for fraud. They're alleging he didn't just make a mistake, he lied. In a normal scenario, Mark's lawyer would fight fiercely to get that fraud claim dismissed, arguing it's baseless and designed to inflame the jury. But Mr. Davis, the insurer-appointed lawyer, has a different incentive. What if the insurance company could prove that Mark did commit fraud? It would be a disaster for Mark personally and professionally. He could lose his license. He could face financial ruin. But for the insurance company, it would be a home run. It would mean their policy's fraud exclusion kicks in, and they owe $0 on a potential multi-million-dollar judgment. So what does Mr. Davis do? Does he fight to get the fraud claim thrown out? Or does he let it breathe? Does he allow the plaintiff's lawyers to explore that theory in depositions? Does he fail to object to certain lines of questioning? Does he maybe even guide a witness toward an answer that, while damaging to Mark, is an absolute godsend for the insurance company's coverage position? This is the ultimate nightmare. The attorney is sitting in a deposition being grilled by the opposing counsel, and their own lawyer, the one sitting right next to them, the one they are paying tens of thousands of dollars in premiums to have, is not their shield. He is a silent accomplice to their execution. He is playing a different game. He is not trying to win the case for his client, Mark. He is trying to lose it in a very specific way, a way that benefits his true master, the insurance company. Mark feels it in his gut. The strange questions. The lack of vigorous defense on certain points. The way Davis seems to concede arguments that could have been fought. He feels like he's being managed, handled, and steered toward a predetermined outcome. He starts to realize the friendly, reassuring lawyer from Smith and Cromwell isn't there to save him. He is the undertaker, politely measuring him for a coffin, all while sending the bill to the deceased. This isn't a rare occurrence. This isn't a story about one rogue lawyer or one bad insurance company. This is the playbook. The reservation of rights letter is the opening move in a chess game where the attorney doesn't even realize they are a pawn, about to be sacrificed to protect the king. The insurance company's profits. The psychological toll is immense. The attorney is isolated, paranoid, and trapped. The very system they dedicated their life to, the system of advocacy and trust, has been turned against them by their supposed protectors. This feeling of utter helplessness is by design. The insurance company wants the attorney to feel trapped, isolated, and powerless. But there is a little-known counter-move. A legal strategy so powerful it can turn the tables on the insurer, forcing them to abandon their games and honor their promises. It's a concept born from the very conflict of interest they exploit, and it's the one thing your insurance company prays you never learn about. This powerful legal weapon is known as insurance bad faith. And it's not just a simple breach of contract. It's something far more serious. When you have a normal business contract, say you hire a supplier to deliver 10,000 widgets and they only deliver 9,000, that's a breach of contract. You can sue them for the value of the missing 1,000 widgets. The damages are predictable, limited to the terms of the deal. You get what you were promised and that's the end of it. But an insurance policy is not a normal contract. The law in most states recognizes it as a special relationship. Why? Because of the massive inherent imbalance of power. When you buy an insurance policy, you're paying money now to protect yourself from a future catastrophe you hope never happens. You are completely dependent on the insurer to be there for you at your absolute lowest moment. They hold all the money. They write the impossibly complex policy. They have armies of adjusters, investigators, and lawyers. You have a crisis. Because of this special relationship, the law imposes a higher duty on the insurance company. It's not just a duty to fulfill the contract. It's a duty to act in good faith and fair dealing towards you, their policyholder. They have to treat your interests with the same consideration they give their own. They can't put their own financial interest in saving money ahead of your right to the protection you paid for. When an insurer unreasonably denies, delays, or underpays a claim, they aren't just breaching the contract. They are committing a separate legal wrong, a tort. And this is the distinction that changes everything. Because when you sue for a tort, the damages are not limited to the policy. You can recover damages outside the contract. This is what lawyers call extracontractual damages, and it's the single most terrifying phrase in the insurance industry. Let's make this real. Imagine a lawyer, let's call her Sarah, has $1 million malpractice policy. A former client sues her, claiming she made a mistake that cost them $800,000. It's a legitimate claim. The client's lawyer offers to settle the case for $750,000, well within Sarah's $1 million policy limit. All the experts agree it's a reasonable settlement. Settling would protect Sarah completely. Her insurance company would pay the $750,000, the case would be over, and her personal assets would be safe. But her insurer's claims adjuster gets greedy. He thinks, there's a small chance we could win this at trial. Maybe 10%. If we win, we pay nothing. If we lose, we'll probably get hit for the full $800,000, maybe more. But I'm willing to roll the dice to try and save the company $750,000. So the insurer rejects the reasonable settlement offer. They are now gambling. But they aren't gambling with their own money. The most they can lose is the $1 million policy limit they were already on the hook for. Who are they really gambling with? They're gambling with Sarah's entire life. They are gambling with her house, her savings, her kids' college fund. The case goes to trial. The jury is furious with the mistake Sarah made, and they award the client a judgment of $2 million. Now what happens? The insurance company pays its policy limit of $1 million. Sarah is now personally on the hook for the other $1 million. She is facing financial ruin. Why? Because her insurance company, the one she paid to protect her, chose to risk her financial future to save itself some money. That is a textbook case of insurance bad faith. And now, Sarah doesn't just have a claim against her insurer for the $1 million policy limit. She can now bring a new lawsuit against her insurer for acting in bad faith. And in this new lawsuit, the damages are catastrophic for the insurance company. First, she can sue for the entire amount of the judgment against her, all $2 million. The $1 million excess verdict that the insurer's gamble created? The insurer is now on the hook for it. The policy limit becomes irrelevant. Second, she can sue for emotional distress. Think about the years of sleepless nights, the anxiety, the damage to her reputation, the terror of facing bankruptcy, all because her supposed protector betrayed her. A jury can put a huge number on that suffering. Third, she can recover all the attorney's fees she had to spend to hire her own lawyer to fight her own insurance company. The insurer is now paying for the legal fight against itself. But here is the real thermonuclear weapon, the one that makes the blood run cold in the executive wing of every insurance headquarters: punitive damages. Punitive damages have nothing to do with making the victim whole. They exist for one reason and one reason only: to punish the wrongdoer for outrageous conduct and to deter them and every other insurance company from ever doing it again. A jury looks at a multi-billion-dollar insurance corporation that crushed an individual for profit and decides to send a message. So, on top of the $2 million for the judgment, the emotional distress damages, and the attorney's fees, a jury might award Sarah $10 million, $20 million, even $50 million in punitive damages. They are telling the insurer, "Your behavior was so socially unacceptable, so malicious, that we are going to inflict a level of financial pain that you will never forget." Suddenly, a dispute over a $750,000 settlement has morphed into a potential $30 million corporate disaster. This is why bad faith is the ultimate leverage. The moment a lawyer can build a credible bad faith claim, the entire power dynamic flips. The adjuster is no longer a bureaucratic gatekeeper trying to minimize a payout. They are a risk manager staring into the abyss of unlimited liability. Their primary job is no longer to save the company money on the claim. It's to save the company from a bad faith lawsuit that could cost 50 times more. The threat alone changes everything. The phone calls get returned. The lowball offers stop. The unreasonable demands vanish. Because they know that their internal memos, their emails, their adjuster's notes, all of it, could become Exhibit A in a bad faith trial, where a jury gets to see exactly how they put their profits ahead of their promise. This legal doctrine transforms the insurance policy from a simple contract into a sacred trust. And when that trust is broken, the consequences aren't just financial, they're existential. But knowing this doctrine exists is one thing. Recognizing the subtle, insidious ways insurers commit bad faith in the real world, that's a whole different level of insight. And those tactics are far more common and far more deceptive than you could ever imagine. One of the most common is what lawyers call death by 1,000 paper cuts. It's not a flat-out denial. It's worse. It's a slow, bureaucratic strangulation. The insurer doesn't say no. They say, "We need more information." First, it's a request for your entire case file. You send all 10,000 pages. A month later, you get a letter. "We've received the file, but we need you to fill out supplemental Form 7B. You fill it out. 2 weeks later. "Thank you for Form 7B, but it appears you signed on the wrong line. Please resubmit." You resubmit. Another month passes. "We've reviewed your file, but we need a certified copy of the court transcript from a hearing that happened 3 years ago." Each request seems reasonable in isolation, but together they form an impenetrable wall of delays. The goal isn't just to postpone payment. The goal is to exhaust you, to make the process so frustrating, so time-consuming, and so mentally draining that you either make a procedural mistake they can use to deny the claim, or you become so desperate to make it all stop that you accept a settlement offer that's a fraction of what you're owed. They are weaponizing the one thing a lawyer under fire doesn't have: time and mental bandwidth. Then there's the insidious tactic of the shifting justification. This one is a masterclass in psychological warfare. Let's say your insurer initially denies your claim based on a specific policy exclusion. Let's call it Exclusion A. They send you a formal letter explaining, in great detail, why your situation falls squarely under Exclusion A. So you or the lawyer you hire to fight your insurer spend the next 6 months and $50,000 in expert fees building a rock-solid case proving that Exclusion A absolutely does not apply. You gather evidence, you get expert opinions, you write extensive legal briefs. Finally, you present this mountain of proof to the insurer. Their response? It's not a negotiation. It's an email that says, "You know what, you're right. Exclusion A doesn't apply. Our mistake." However, we are now denying your claim based on exclusion C, an exclusion they never once mentioned before. All that time, all that money wasted. You've been chasing a ghost. The insurer didn't have a good faith reason for denial. They were just cycling through excuses, hoping one would stick. This isn't an investigation. It's a fishing expedition. It shows that their initial denial wasn't based on a careful review of the facts, but on a predetermined goal. Don't pay. They force you to debunk one reason, then they just invent another, moving the goalposts over and over until you run out of money, energy, or both. This perfectly sets the stage for the lowball offer. The insurer knows you're bleeding. Your reputation is taking a hit, you're paying for your own defense while fighting them, and the stress is keeping you up at night. They've worn you down with delays and shifting justifications. Now they come to the table. Let's say the malpractice claim against you is for $1 million. The insurer, after months of silence, offers you $50,000 to settle. It's a shocking, insulting number. But it's not designed to be accepted. It's designed to be an anchor. It psychologically frames the negotiation around an absurdly low number. Your brain is now anchored to $50,000. Over the next few months, they might graciously increase their offer to $75,000, then to $100,000. To an outsider, it's still a ridiculous offer. But to you, who has been through months of hell, that doubling of the initial offer feels like a monumental victory. They've made $100,000 feel like a gift. They are preying on your fatigue, making you grateful for scraps because you're too tired to keep fighting for the meal you're actually owed. They turn the process into a grueling test of endurance, knowing that most people, even tough lawyers, have a breaking point. Perhaps the most structurally deceptive tactic involves something called a reservation of rights letter. When you report a claim, the insurer might send you one of these. It sounds official and almost helpful. It says, "We will pay for a lawyer to defend you against this malpractice suit, but we reserve our right to later deny coverage if we discover your claim isn't covered by the policy." On the surface, this seems fair. But here's how it's used in bad faith. The insurer is now paying for your defense lawyer. They have a say in legal strategy, but their interests are now completely opposed to yours. You want to defend the case vigorously and prove you did nothing wrong. The insurer, however, might want the case to develop in a way that helps them deny your coverage. For example, the malpractice claim against you might involve allegations of simple negligence, which is covered, but also allegations of fraud, which is not. Your defense lawyer, paid by the insurer, might be subtly encouraged by the insurer to focus less on defending the fraud claim. If you end up being found liable for fraud, the insurer can then turn around and say, "See? The final judgment was for fraud, which is excluded from your policy. We no longer have to cover the damages. Here's the bill for the defense, by the way." You were given a defender who was serving two masters, you and the company actively looking for a reason to abandon you. It's a terrifying conflict of interest, and you're trapped right in the middle of it. And sometimes the deception is much simpler. They just lie. An adjuster, knowing full well that most lawyers are experts in their own field, but not in the arcane language of insurance contracts, will simply misrepresent the policy. They'll get on the phone and say with complete confidence, "I'm sorry, but what you're describing falls under Section 4, subsection D, Part 2, which clearly excludes claims arising from failure to file. There's nothing we can do." They are banking on the fact that you won't immediately pull out your 120-page policy, find that specific clause, and analyze its legal precedent. They're using their specialized knowledge against you, creating an illusion of authority. By the time you get suspicious and have another lawyer review the policy, you might find that the adjuster took the clause completely out of context, or that court rulings in your state have rendered that exclusion unenforceable in your specific situation. But they've already caused months of delay and despair, all based on a deliberate misreading of the very contract they wrote. You have to understand, these tactics are not the work of a few rogue adjusters. For many in the industry, this is the playbook. It's a business model. An insurance company's profit is the sum of premiums it collects minus the claims it pays out. Therefore, every dollar not paid out is a dollar that goes straight to the bottom line. The adjuster's job, their performance reviews, their bonuses are often tied to a metric called claims leakage, how little money they let leak out of the company's coffers. They are financially incentivized to delay, deny, and underpay. They are not your partner. They are not your protector. They are your adversary in a high-stakes financial negotiation where they hold almost all the cards. And that is the secret. That is the fear that lives in the back of every attorney's mind. It's not just the fear of making a mistake. It's not just the fear of being sued by a client. It is the terrifying, soul-crushing realization that after paying tens, or even hundreds of thousands of dollars in premiums over a career for a promise of security, that promise can evaporate at the precise moment you need it most. The ultimate nightmare is not fighting a lawsuit. It's fighting a war on two fronts simultaneously, against the person suing you in the front, and against the supposed ally who is stabbing you in the back. It is the profound betrayal of being left completely alone, exposed, and financially ruined by the very shield you paid a fortune to carry. The greatest risk a lawyer faces isn't an angry client or a difficult judge. It's the cold, calculated fine print of their own insurance policy, and the knowledge that the person on the other end of the phone has a playbook designed to break them. They sell a promise of protection, but in the brutal calculus of a billion-dollar industry, that promise is often just the opening move in a game you are set up to lose.